So we want to welcome all Towson University alumni, OSHA members, faculty, staff, and friends. I'm Steve Rosenfeld. I'm the Director of Alumni Communication and Recognition for Towson University. I want to thank all of you for joining us today for this webinar, Keys to Successful Estate Planning During Times of Uncertainty. We are very excited about today's event, which is co-sponsored by OSHA and my office, the Office of Alumni Relations. This session will be recorded and will be shared with all event registrants when the registration video is finalized. Attendees will remain muted throughout the discussion. If you have any questions, please use the chat function, which is in the bottom right of your screen, and I will ask the questions on your behalf at the conclusion of the presentation. If you prefer to ask the questions yourself, please type in the same chat box, "I have a question," and I will, at an opportune time, I will unmute you and let you ask the question yourself to our presenters. So I'd like to thank Kathleen Hyder from the University Advancement Division for helping make today's presentation possible. I'd like to welcome her and introduce her as she has a few words of welcome. Kathleen?
Hi everyone. So I'm really glad that everyone could join us today. I also want to take a moment and thank our co-host for the seminar, Tracy Jacobs, Director of OSHA Lifelong Learning Institute at Towson University, and Steve, that you just heard from. Steve is Director of Alumni and Communications for Towson. And I'm also really grateful for your time and efforts because, as you know, we originally planned to have our speakers join us live in March. And of course, the pandemic had different plans. I'll tell you, though, what I've learned during the last 9 months is that we're much more resilient than we realized. And we've been able to rethink and devise new strategies for the way we do things, the way we do everything now. But this time of crisis has also shown me, especially, how important it is to be prepared, in all aspects of our life, planning for the future. And so today, our topic, keys to successful estate planning, it's so on target. It was in March, and it's probably even more so. Our speakers today include Neil Cummins, Principal of Cummins and Associates Financial Group. He is a Towson University alum, class of 1986, and he earned a Bachelor's of Science in Business Administration with concentrations in Management and Marketing. A financial planner for the last 21 years, Neil's specialties include retirement planning strategies and cash flow analysis. He and his wife of 22 years, they live in Harford County, and they've raised 3 children, 17, 19, and 21 years of age. And I would be remiss if I didn't mention the pride of the Cummins family, Josie, their chocolate lab. Because, as he said, dogs are people too. So Tom Weld is also a Towson University graduate from the class of 2019, and he started his career as a financial services representative immediately after graduation. He works with Neil at Cummins Associates Financial Group, and he is currently pursuing his investment licenses and is focused on working with individuals and families. Outside of his practice, Tom serves on the Young Professionals Board for the First Tee Greater Baltimore, which is a nonprofit organization dedicated to impacting the lives of Greater Baltimore youth through the game of golf. And then we have Mariella D'Alessio, a partner with Smith, Gilday, and Schmidt of Towson. Mariella graduated from Villa Julie College, now of course Stevenson University, with a Bachelor's of Science in Paralegal Studies, and she worked as a paralegal for 3 years prior to going to law school. She earned her law degree for 2.5 years from Florida Coastal School of Law. She passed the bars in Florida, Maryland, and Pennsylvania. Now, Mariella has been practicing law for about 10 years now. So although she's not a Towson Tiger, she married one, and they have a little boy, almost 8 years old. So I want to thank you, Neil, Tom, and Mariella for joining us today. And I'm going to hand you back to Steve, who will be the master behind the scenes here. Thank you so much.
I will be your moderator today. But again, I don't have any work to do until these great presenters get to their presentation. So I will sit back, relax, and enjoy it, as I hope you all enjoy as well.
Okay, I'm going to go ahead and share my screen with everyone. We're going to go ahead and get started. Again, my name is Neil Cummins, one of the principals with the Cummins and Associates Financial Group. Today, we're just going to briefly speak about, for the next 45 minutes to an hour, we'll try to have this completed as close to 1 o'clock as we possibly can, and go through some of the different aspects of financial planning, estate planning, that we need to be focusing on, not just during times of crises, but whether or not we're experiencing a pandemic as we are right now, and some of the fundamentals that we need to be focusing on. Through the presentation today, I just want to make sure that we are not here to give you any specific tax advice or legal advice. While we are going to talk about some legal topics today, we are not really addressing anyone's individual personal legal situation. You will have an opportunity to communicate with Mariella and reach out to her after the presentation if you so desire. But again, like Steve said, certainly feel free to use the chat feature on your lower right-hand part of your computer screen if you have questions. And we want to try to keep this informal as possible. So if you have a question that you want to ask right now and have answered while we're looking at a specific screen during the presentation, certainly feel free to reach out. As Steve said, he will unmute you. If need be, we will answer any questions that we receive at the end of the session. So when we talk about estate planning or financial well-being together in one piece, again, it's having control day to day and month to month over our monies and our legal situations, having a capacity through it all to absorb a financial shock. And while we may all be a little bit happier now with our investments, if we go back several months to March 23rd, when the values were probably somewhere between 40 and 50% lower than they are right now for most people, we certainly realize that a lot can happen quickly and many things can change quickly. You know, we want to make sure that from the financial side of the tracks that we're certainly doing what we need to do to meet our financial goals so we can maintain a successful retirement. But we also need to focus on the legal aspect. And that's a little bit about what we're going to be talking about today, so that we can have the peace of mind to know that, God forbid, something should happen to us, that we are both prepared, not just financially, but from a legal perspective, to talk about some of the different topics that are involved with estate planning. And we've got the four on the screen right now. At this point, I'm going to turn it over to Mariella, and I'm going to let her take over the conversation and present the information on the slides and then answer any questions that you may have throughout the presentation. Mariella, the floor is yours.
Great, thank you. Hope everybody's doing well today. So as you can see on the screen, we have 4 different topics that we're going to be talking about. First of which is what is an estate plan, tools in estate planning strategies, and other considerations. So let's go ahead and start with the first slide. So what's an estate plan? So essentially, when you pass away owning assets, an estate plan essentially will lay out what happens to those assets. So we are talking about real estate, we're talking about bank accounts, investments, life insurance, tangible personal property, which is anything that you can touch with your hands. You want to make sure that you put in place basically an outline of where you would like those assets to go upon your passing. So an estate plan is important for various reasons, some of which are listed right here. The first of which is establishing beneficiaries. You've worked your life to create assets and wealth, and you would want to make sure that you're directing where those assets go upon your passing and not leave it to chance or the state of Maryland to direct otherwise. Along those lines, it allows for a smooth transition of your assets to your beneficiaries. And here are some of the tools that you can essentially utilize in a full and proper estate plan. There's wills, there's trust, there's gifting strategies, as well as life insurance. So wills essentially are the traditional method of your estate plan. This is how the majority of individuals transfer their assets upon their passing. So within this document, you will identify beneficiary designations. So again, those are the individuals that are to receive specific assets that you own at your passing. Within this document, you'll also identify who will act as your executor. Maryland also calls that personal representative, who is the individual in charge of administering your estate and carrying out the wishes that are set forth in your last will and testament. You can also direct within your will any instructions that you want to specifically identify for individuals. For example, if there are minor children, do we want continued trust in place so that they're not getting outright distributions upon your passing? We can ultimately delay distributions to certain target ages. The beauty of an estate plan is that it's unique to you, and we can draft a document in accordance with your specific wishes. Something that is also incredibly important is for all of those that have minor children. Within your last will and testament, you are going to specifically nominate the individual that if you were to pass away and still have minor children, who would you want to step in that shoes from a parental standpoint and take over the day-to-day activities in serving as guardian of your minor children? Another method of transferring your assets would be a trust. There are various types of trusts. We're going to be talking pretty generically about trust in general here. So trust allow you to minimize estate taxes. There are certain provisions that can be included in any trust for purposes of avoiding creditors. So there's asset protection provisions that can be included. We typically call them spendthrift provisions. It allows to provide support for grandchildren with special needs or anybody with special needs for that matter that you would like to leave assets to. You can also use a trust to fund charities of your choosing. And also it is allowed to distribute assets before and after death. There is something called a revocable living trust, which comes into existence during your lifetime. And then ultimately upon your passing, it becomes irrevocable. There's also something called a testamentary trust, which is a trust that's created under your last will and testament. So again, two mechanisms for transferring assets, traditional last will and testament route versus the revocable living trust route. Other ways of transferring your assets would obviously be gifting. So there are certain parameters that allow you to gift during your lifetime on an annual basis without there being any reporting requirements. So as of right now, and it probably will increase in 2021, but any individual can gift up to $15,000 per individual per calendar year without any reporting requirements. So there's no tax burden to the person that is receiving the gift, nor is there a tax burden to the person that's giving it. So there's no reporting requirements. Anything above that $15,000 would in fact require a gift tax return. So I always caution, if you're going to gift above that amount, please make sure you speak with your certified public accountant to assist in preparing a gift tax return for that specific gift. You can also receive an income tax deduction in the event that you gift to a qualified charity, whether during your lifetime or upon your passing by virtue of a trust agreement. Life insurance is an incredibly important tool, and it provides liquidity to an estate in the event of your passing. So if there are debts that are basically owned by you at the time of your passing, life insurance proceeds can be used to pay them off. In addition, you can also fund and distribute wealth to beneficiaries outside of your estate. Ultimately, a life insurance trust is something that exists for individuals that want to make sure that if there's tax consequences, there's liquidity to pay it. And then there's also a way to transfer those assets tax-free to beneficiaries. And that is something, again, anytime there is a beneficiary listed on an asset, it goes directly to that individual and would bypass probate, also known as passing outside of your estate to that specific beneficiary. Estate planning strategies. So this is the typical method for estate planning for married individuals out there. It's a simple will that essentially leaves everything to a single person, which is typically surviving spouse or partner. And then ultimately, upon the second spouse's passing or partner's passing, most assets are divided equally among grandchildren and or children. Typically, it flows down to the next generation, which would be children. Oftentimes, I have clients that want to leave a specific sum of money or a portion of the estate to grandchildren, which can also be incorporated into a traditional last will and testament. Other portions of the will that need to be incorporated and need to specifically be identified are the costs associated with your passing. Ultimately, any debt that is associated with you individually is a responsibility of the estate assets for purposes of payment. Things that need to be specifically identified in your last will and testament is your preference of burial versus cremation and the direction of the personal representative, also known as executor's ability to pay those expenses associated. In addition, there's inclusion in there if there are any sort of death taxes that are due as a result of your passing, whether it's inheritance, transfer, or federal or Maryland estate taxes. That should be specifically identified in the last will and testament as well, that your personal representative has the authority to pay them, along with any legal fees, as well as accounting fees that might be associated from tax returns that need to be completed upon your passing. Oftentimes there's language in there with regards to real estate. If it is still an encumbered piece of property that has a mortgage or a HELOC associated with it, your will can specifically direct that those debts are to be paid off from the estate assets so that the beneficiary receives those assets free and clear of any liens or encumbrances. And a lot of times too, I have clients that like to gift during their lifetime to their children or grandchildren. Oftentimes they say they want that beneficiary to take advantage of it while they're alive, and they want to witness the benefit and them enjoying the gift that they're giving during their lifetime. And as a result of that, a lot of times my clients will play catch up within their last will and testament and or trust in making sure that they're being fair to all of their children and grandchildren, and that one child or grandchild is not getting more than the others to not cause any tension unnecessarily on the back end. So with regards to your specific will, we can incorporate language to ensure that there is equalization among all assets so that all beneficiaries are treated fairly. Gifts that keep giving strategy. So again, I briefly touched on this before. I apologize, I jumped the gun a little bit, but the federal gift tax exemption amount for individuals right now is $15,000. Again, it's slated to increase in 2021. It increases every year. And ultimately, you can gift $15,000 per person, or a married couple can gift $30,000. For example, if you have a child and a child's spouse, you can give $15,000 to your child and then $15,000 to your child's spouse, which would be $30,000. And your spouse could also do the same thing. So ultimately, you could end up gifting $60,000 per year to a married or partnership without there being any sort of tax consequences, whether to the recipient or the giver from a reporting requirement. Again, the amount and timing of gifts are entirely up to you, but this is a way to stay under the reporting requirement by adhering to the federal exemption threshold, which again is $15,000 currently. In you and I trust. So I touched on this again briefly, but there is something called an irrevocable trust that ultimately is something that supplements your last will and testament. So you are putting assets in an irrevocable trust, and ultimately you are giving up incidents of ownership or control. And for that reason, it is not included as a part of your estate as being something that is owned by you. Therefore, there are no tax consequences associated with the assets that are specifically allocated to this irrevocable trust. Oftentimes, individuals take advantage of life insurance in this manner. It is something called an irrevocable life insurance trust that is owned by this trust. And again, it's for purposes of estate taxes that ultimately might be due at the time of your passing. And it also takes that proceed benefit from that life insurance policy out of your estate for tax purposes. And Neil, I'm sure you have clients that ask you about that often with regards to life insurance. And could you shed a little light on whether you think a term life versus a whole life, or what your recommendation would be for life insurance associated with an irrevocable life insurance trust?
Yeah, and again, it's a great point, Mariella, that when we talk about using life insurance in an irrevocable trust, basically we have three different types of life insurance that we deal with within the industry that's available to the consumers. We have term, we have universal life, and we have whole life. So when you look at the permanent options are universal life and whole life. So if we're putting a life insurance strategy in place inside of an irrevocable trust, what we don't want to use is we don't want to use a term policy, because a term policy really is more appropriate for younger folks. Say you got married and you just bought a house, maybe you've had children, and now you think, okay, I need a little more death benefit payable, but I want to try to make it as affordable as possible. So when we talk about a term policy, most term policies, if we do a 20 or a 30-year premium guarantee, that premium, say for a 20-year term policy, is guaranteed not to change for 20 years. But in year 21, a premium that may be $2,500 a year jumps up to be $30,000 per year. And then all of a sudden, the premiums become so exorbitant that people lapse term policies. So when we're talking about using life insurance as an estate planning strategy, we're going to focus on either universal life or whole life. And when I'm developing plans for my clients, I am more using universal life as opposed to whole life. Because in just about every single case, the goal is to maximize the death benefit payable for the least amount of premium that we want to pay into the policy. So with universal life policies, the focus is not only accumulation of cash value. With whole life, there's a cash value accumulation feature, which is wonderful for other uses, but for the purpose of estate planning and purchasing a life insurance policy to put into some type of, say, irrevocable life insurance trust, we're going to use a universal life policy in most situations.
Got it. And something else that I recommend for my clients, which is kind of a little bit, we're at about 5,000 feet up from an estate planning standpoint, but oftentimes I have clients that are asking about long-term care. And I know that that is something that is afforded with regards to life insurance. And so I know that you are fully knowledgeable of that and can provide any guidance to anybody that has questions on it. But it is something that I recommend to my clients if they're interested in aging in place as a part of their entire estate planning strategy. That's something that I, implore them to have a conversation about sooner than later as a result of, cost effectiveness and making sure that they get it at the right moment.
Right. If I can take a second and just touch on long-term care insurance, when I'm sitting down and I'm creating a financial plan for clients of mine or prospective clients of mine, there's really two things I tell them that I preach until I'm blue in the face. On the investment side of the ledger, it's that Roth IRA, because we put money into a Roth IRA, the monies grow tax deferred, and then in retirement, the monies come out and they give me access tax free. So if those monies are invested through the years and you've got accumulation in the account value, that money's going to come back to you tax free, which is going to be big for tax purposes moving forward, because we may not realize it right now because we feel like we're getting taxed from so many different directions. But we are in what is considered a historically low income tax rate environment. So Roth IRAs, income that we start taking in from Roth IRAs later in life, don't count towards taxable income. It also may keep you below the income threshold necessary so that maybe your Social Security benefits wouldn't be taxable either. The challenge is, in order to make contributions into a Roth IRA, you have to have earned income. Unless if you're retired, we can take a traditional IRA and convert that to a Roth IRA, which is a tremendous estate planning tool also. But if I'm focusing more on the protection side of the ledger for the purposes of our conversation today, and we're talking about insurances and more specifically long-term care insurance, again, long-term care insurance is such an important piece of the pie. I know the premiums can be expensive. And, I'll ask my clients, what's a scenario that we look at that's a little more palatable? Paying somewhere between, say, $7,000 and $10,000 a year for long-term care insurance, or taking the risk that if we don't have long-term care insurance and something happens to us later in life, that we've got to pay that cost of care out of pocket. And I've got a nice piece, I don't know if I'm going to have time to share it today, that talks about the cost of care. And right now, when we look at the greater Baltimore metropolitan area and really the Mid-Atlantic in general, the cost for care for a semi-private room, nursing home care in this case, it's already above $100,000 per year. So what's more palatable, paying, say, $10,000 a year, and that's probably on the high side for a long-term care insurance premium, or paying $10,000 per month if and when care is needed? So it's a little bit of a challenge, and we can turn a blind eye to it, but that's usually not the best resolution, because we know that when we get to retirement, that more than 50% of the population will need some type of long-term care before they pass away. That's why it's such a huge priority.
I did notice that there was a question that came in, and since we're talking about insurance, could you explain again, Neil, the difference between whole and universal life insurance?
Okay. Yeah, it's a great question. So if we're looking at universal life insurance on one side of the ledger and whole life insurance on the other side of the ledger, for that whole life product, the premiums are for all intents and purposes, more expensive than universal life premiums. Because with a whole life policy, you've got the accumulation of cash value in that policy. And then the death benefit tends to increase through time as the dividends and the cash value continue to increase through the years. But with a universal life policy, the focus is maximizing the death benefit payable for the lowest possible premium that we can pay. So when we think about a universal life policy, there really is no cash value. So you may have cash value over here inside of the whole life policy. However, when we talk about death benefits, your death benefit is going to be higher inside of that universal life policy in just about every case. So when we're using life insurance for estate planning purposes, and just about, again, in just about every situation, not every situation, but just about every situation, the goal is to maximize the death benefit that we're purchasing with the premium that we're paying in to help offset taxes that may be due when the estate transfers to the beneficiaries, to help increase the total value of the estate that we're going to transfer to beneficiaries. So when we're thinking about the differences between the two, whole life insurance tend to be more expensive when compared to universal life. The benefit with whole life is that it accumulates cash value through the years, but that may not be a priority when we're talking about life insurance for estate planning purposes. I hope that clarifies it a little bit.
I think it was incredibly helpful. Let's see here. So actually, if you could go back one slide, I just wanted to touch briefly on these different strategies. So again, drafting an estate plan is unique to your specific wishes in accordance with your financial well-being, your financial plan for the future for both your beneficiaries. And so anytime you draft an estate plan, it is very likely that there'll be a combination of these four tools. So whether it's a traditional last will and testament, some gifting strategies that are either put in place during your lifetime or ultimately upon your passing to a charitable entity, a component of life insurance, whether it's owned by a trust or individually, as well as a testamentary trust versus a revocable living trust. Usually all four of these are used for most estate plans. Again, each individual's case is unique to their specific wishes and desires, and we have all of these tools available to accomplish those goals. I think I do see another question as well with regards to life insurance proceeds held outside of a trust. So this is the typical lawyer answer, in that it depends if they're taxable, if they're owned outside of your estate. Anytime you own a life insurance policy, it is synced up with your personal Social Security number. So at the time of your passing, anything owned by you is ultimately subject to taxation if you are over the certain threshold for both the Maryland state tax versus the federal. Maryland right now is $5 million per person that you can own at the time of your passing with no tax consequences. Federal is a little bit over 11.2 million. Again, that is right now at the current time. Next year, Maryland is supposed to stay the same. Federal is supposed to increase a little bit, but most likely the federal tax laws are going to sunset in 2026. So your guess is as good as mine of what we're going to be dealing with in the future from a federal tax standpoint. Okay, roll the dice strategy. So I have to advise that this is probably something that I'm most adamant about not falling victim to. So ultimately, if you pass away without having an estate plan in place, there's something called intestacy laws. And this is something that is true in every jurisdiction in the United States. But basically, it is a default distribution plan of where your assets would go ultimately upon your passing if you did not have an estate plan in place. It basically goes to the next heirs at law. So by way of example, if I were to pass away, I obviously am married and I have a child. If I didn't have a last will and testament, which for the record I do, but if I did not, then ultimately I would have to, my husband would split my estate half with me after getting his spousal share, which is $40,000 off the top. He would take one half the balance, and then the other half of the balance would actually go to my child. So there's a misconception that spouses would leave everything to each other or partners. If there are assets in your name individually, that is not the case. If there are joint assets, obviously that is a different story, because by virtue of the titling, it would go to the joint owner as the surviving owner. But there are circumstances where, for example, if I did not have a child, there are mechanisms in place that ultimately, if my husband passed away and he did not have a will, I would take the spousal share of the first 40,000. And then based off the duration of the number of years I have been married to him, there is a possibility, since both of my in-laws are still alive, that I would have to share my husband's estate with my in-laws. So ultimately, it's important, especially for situations in which you have estranged family members, you need to make sure that you are directing where your assets go and don't leave it to the state of Maryland to make that decision for you. The way, just talking generally, is it goes to down the tree basically to children. If there are none, it goes up the line to parents. If there are none, it comes back down to siblings as well as nieces and nephews. Goes a little bit further out, but ultimately for Baltimore County specifically, if there are no heirs at law, then ultimately it would go to the Board of Education for Baltimore County for purposes of funding schools. So again, other considerations that you should take into consideration is the fact that estates can be very complex. And as I touched on as well, I don't have a crystal ball to know what is going to happen with all of the ever evolving tax laws, as well as just laws within the state of Maryland. So it's important that you have a team in place. I'm very much on the approach of it being a team and act, as well as Neil, I feel like you agree with my sentiment that is very much a team approach. I never want to do anything that is contradicting what the financial advisor is recommending versus what the CPA is recommending. So it is a holistic team approach with all of the players in the room or virtual room these days to ensure that your estate plan is being put in place to accommodate your wishes and your goals, all while being compliant from a tax perspective, a legal perspective. This has been a very unique year with 2020, and there have been some changes in emergency orders that have been put in place in light of the pandemic. For the first time ever, Governor Hogan did actually sign an executive order that allowed us to do remote execution of estate planning documents. People were a little bit panicked with regards to the pandemic and all of the unknowns associated with that. And a lot of clients have ultimately decided that, you know, they'll get to their estate planning and they might have been kicking the can down the road, so to speak, for a few years. And now with people working from home, there's been a lot more proactiveness of individuals to try to get this accomplished. So again, for the first time ever, Governor Hogan did sign an emergency order to allow that. I will tell you, though, that as of October 1st of 2020, there was a new law that was slated to come into effect, and it did actually come into effect with regards to remote notarization. As a result of that new law coming in, Governor Hogan did not extend the emergency order to now allow for estate planning documents to be done virtually. So we are back to traditional signing appointments. We are doing in the office, ultimately socially distanced. We are also doing curbside signing appointments. We are not offering food services associated with curbside, but it is for people's safety and convenience if they are still a little uneasy or uncomfortable about going into a building. We certainly are okay with accommodating clients that like to just be a little bit extra cautious. We have put in some requests to the legislature in hopes that Governor Hogan might extend this order, ultimately bring it back, as there are other jurisdictions, for example, Florida, in which I'm also licensed. They actually have been allowing remote notarization of estate planning documents, regardless of the pandemic being an issue. But we have not heard any definitive feedback of whether or not it's going to be extended. So we are still going to proceed in the traditional method, compliant with the law of doing either curbside or in-person signing appointments. But it is, again, a very unique time. And so for individuals that have thought about wanting to do this, it is probably a good time, just with all of the unknowns out there until the vaccines potentially are available to everybody, just to maybe take some time to be proactive and get your estate planning put in place. So some of the things we also want to point out is, again, remembering the significance of an estate plan. This is something that you're going to put in place now, but it's ultimately going to be something that you're going to revisit every few years. It's not you put it away and just check it off the list. As the laws are changing, as your financial well-being is changing, as tax laws are changing, it's something that you're going to want to revisit on a regular basis. Neil, I know you meet with your clients, whether it's annual, biannual, quarterly, it's really dependent on the clients. And so I know that you are always meeting with them to make sure that whatever, you're handling from a financial standpoint is still accurate and in accordance with their wishes and goals. And I do the same thing with my estate planning, not as often as you are, but every few years I do, reach out to my clients to make sure they pull out those documents and take a look at them. It's important as well that you consider your legacy goals. Do you want to put continuation trust in place for grandchildren? Do you have charitable intentions that you want to make sure are being abided by? These are all things that need to be put in place by you as the person creating the will. Either a testator or testatrix is the formal definition of that term. So ultimately, we always recommend that you begin with the will and also consider other types of the estate planning tools that we discussed today. Ultimately, some other documents that we didn't talk about that I just want to touch on very briefly that are significant as well would be your traditional advance directive, medical and financial power of attorneys as well. Again, an estate plan is comprehensive and unique to you individually, but 99.9% of the time, advance directive, medical and financial power of attorneys are going to be a part of the estate plan that you put in place.
Okay, thank you for unmuting me there. I took notes as we were speaking that when I sit down and I meet with my clients from the financial planning end of the spectrum, I make sure that I stress to them that those 3 documents that we need to have in place, the will, that durable power of attorney, like you mentioned for medical and financial, and that advanced medical directive, a living will, I guess there's several different names for it, do not resuscitate. What are your thoughts as far as meeting with a professional, Mariella, to get those documents completed versus in this digital age, people doing it themselves by jumping online on their computer? If they do feel like they want to go online and pursue completing those documents themselves, what should they be aware of and what should they be thinking of?
So oftentimes the online platforms are prepared kind of based off of generic law. I've had a lot of clients that have come to me that have tried to utilize that route. One in particular jumps out at me. She was a Pennsylvania resident and she came to me with a trust for me to take a look at just to make sure it was compliant. And ultimately, when I got to, the very end of this 40-page trust document, the one specific section said that the controlling law was California. And she was not a resident of California in any capacity. So there should be no reason whatsoever that California law controls, because California law is very different from Pennsylvania. So I caution that although it might be cheaper to take that route, this is something that's incredibly important, and I would suggest seeking a professional to either review the documents if you do decide to go that route, or ultimately just to prepare them. And I often do review documents for my clients that have done it, whether they're moving and relocating from another state. I'm happy to look at their documents to make sure they're compliant with Maryland law, or in the event that they do it online, I'm happy to take a look at them just to make sure that there are certain items that are not missing that I believe are imperative to be compliant and effective in Maryland, based off of Maryland law.
Great answer. And I think one of the big takeaways there is that California is certainly different from Pennsylvania, which is different from Maryland. So you need to understand the rules and the specifics of your particular state that you're going to be residing in, where these documents really will be implemented. And I know that I ran into a situation with one of my clients several years ago with the state of Pennsylvania, and it was just so much different from the state of Maryland. And they had no idea. And the documents were reviewed, and we caught it from our end, and they took it back to their legal professional and got it amended. But it's always first takeaway. It's a great idea to have a second set of eyes, take a look at your legal documents just to make sure everything is accurate and the way you want it to be. And when I look at costs, and not just when we're talking about creating estate planning documents, but just in all aspects of our lives. And I'm right up there with everyone else where I'm trying to save money whenever I can, because when it comes to money, it's not the old saying, easy come, easy go. It's hard to get easy go. And the saying that I make sure my clients understand is that cost is an issue in the absence of value. So most of us probably don't drive the least expensive car that the dealership sells. Most of us probably don't live in the least expensive house that's available on the market. Most of us probably have a smartphone and don't have the little flip phone with no internet access, and we pay a lot more money for that smartphone, not just to purchase a smartphone, but to maintain that smartphone every month. But we're willing to pay more for certain items because we realize the value that they bring to us in our lives. So realize that dealing with a live person just provides a lot of value, and I think that is money well spent. And just for kicks and giggles, several years ago, when I first got my documents created, I tried to go online and say, okay, well, how difficult is this to do online? And if everything is very cookie cutter, then it's not too complicated. But for most people, things just aren't cookie cutter, and everybody's got specifics that they want to address that you're just not going to get that level of detail online. So my recommendation is, even though I am not a legal professional, I can give general advice that when it comes time to sit down and really focus on those documents, I would recommend dealing with a person, a live person, as opposed to, a computer screen. A couple of other things. I wanted to go back to the life insurance part because somebody asked a question about life insurance outside of the estate. I think it's very important to understand that if you have a life insurance policy and it's not part of your estate planning documents, and in a lot of cases, people will use life insurance as part of the estate plan to offset estate taxes. But that estate tax number is really high. Mariel, what is it now for a married couple?
So 5 million for married, well, 5 million per person in Maryland, 10 million per married couple because portability is in play.
Right. So, and we're 95% of the population out there, 98% of the population out there, married folks, their estates are going to be worth, below that $10 million threshold. But when you talk about life insurance is a terrific asset, not through some type of trust, whether it's a revocable trust or an irrevocable trust. Well, life insurance is a nice asset to pass monies to beneficiaries because the monies received by the beneficiaries is tax-free. So if you leave behind a $100,000 policy, $1 million policy, your beneficiaries are going to get that money, and it's not going to be taxable income to them. There are no strings attached with them having any obligations to pay taxes of any type from the proceeds received from a life insurance policy. And it gets to the situation that for most people, if we look at our two biggest nest egg parts of our nest egg, it's our house and in a lot of cases, our retirement monies. Say our 401k from while we were working, that maybe we've rolled that money over into a traditional IRA. And we try our hardest in so many cases to not spend that money. And we keep it close to the cuff. And once we get to now, say, the age of 72, because as part of the CARES Act, there's a couple of things that changed with the CARES Act. The required minimum distribution age was raised from 70 and a half from those who aren't taking required minimum distributions yet to the age of 72. So let's say you get to that age of 72, and now you've got to start taking out the required minimum distributions. And we're going to use a round figure here of about 4% because that's what that number is going to be. If you've got, say, $1 million inside of that retirement plan, that means $40,000 has to come out. And what do you do with it? Because a lot of my clients who are taking these required minimum distributions, they don't need the money. And they say, well, eventually it's going to make its way to my kids, to my beneficiaries. Well, and that's where I'll throw out there, how about a life insurance policy? Because now you're taking a smaller bucket of money and you're buying a huge barrel of tax-free money. Because one of the biggest assets that we pass to our beneficiaries, to our children, is that retirement plan, which gets taxed and taxed and taxed. And the rules have changed for distributions from retirement plans when it comes to estate planning. And I think it's an important point to make note that prior to this year, when they passed the Secure Act on January 1st of this year, that's when they raised the required minimum distribution age from 70 and a half up to 72. And there were some other nice provisions with that Secure Act. But one of the negative features of that Secure Act is that prior to it, you could take your IRA money, your retirement plan money, and if you didn't spend it before you passed away, and let's assume if you're married, your spouse has already passed away, then you pass away after after your spouse, now the money's going to go to your children. Because in most cases, that's where it goes. We used to be able to set up prior to January 1 of this year what was called an inherited IRA, to where let's say that child is 55 or 60 years old when you pass away and they inherit that money. Well, now they would have to take out a required minimum distribution from that inherited IRA because let's say you were 85 years old when you passed away. Since you had already started taking required minimum distributions, they have to take them. But now what's changed is that money's all got to come out, not based on their life expectancy. It's got to come out in 10 years. So here they are, let's say they're 55, 60 years of age. They may be in some of the highest income earning years of their lives. And here comes mom and dad's money. And then it bumps them up into a higher income tax bracket. So part of the overall estate planning process is taking a look at these pre-tax monies to make sure that they're not just going to work for you as hard as they possibly can, but also that they'll work hard for your beneficiaries when inherited. I understand we've got some questions. I'm going to stop from my end and let's go ahead and answer some of those questions.
All right, we do have quite a few questions that came in, but it's been a great presentation so far, and people are hungry for more information. So we have the first one: can estate distributions be specified within a trust which should substitute for a will?
Yes. So again, there's two traditional ways of distributing your assets. The traditional method is a last will and testament, or you can do a revocable living trust. And either way, it would specifically identify where your assets would go.
Okay. Next question. 5 years ago, this person set up an IRA spendthrift trust for a disabled 32-year-old relative. It was set up for lifetime annual payouts. Has this changed and trusts must pay everything within a shorter amount of time?
I think that would be grandfathered in since it went into effect prior to the law. So you should be okay. If there are specific questions, I'm happy to address them about this specific trust, but I would obviously need a little bit more information.
Great. Next, we have: my will was prepared years ago when I first moved to Maryland. What is the process for updating an existing will?
So ultimately, it's just taking it to a local attorney to have them review both your last will and testament and any of your other estate planning documents. There are typically reciprocity laws between jurisdictions, but again, each state is specific about the requirements that are needed for your documents to be valid and effective. So a local attorney could review them and make recommendations, or essentially bless them, I quote, to say that they're good to go.
Great. All right. Next, we have: what is your recommendation regarding 2 versus 1 personal reps?
My recommendation is don't do it. So ultimately, personal representatives have to act unanimous in all decisions while serving this role for your estate. And oftentimes, if you have children that are nominated and one lives in California and one lives local, it is unduly delaying and costly to have to constantly have documents back and forth because they each have to sign every single document that's filed with the court. I often say do it in successive order of having one individual followed by individuals after that. Something also is when acting unanimous, if there is a conflict and they are deadlocked, ultimately sometimes that requires court intervention to resolve that dispute or deadlock.
Okay. What is the advantage of having the will filed with the courts prior to death?
There's no legal requirement to have it filed with the court. It's something that each register of will in the county in which you reside offers as safekeeping for a nominal fee. I oftentimes have industrial fireproof safes at my office that I offer the same service free of charge. So it's just an option that if you prefer to keep it there, that's fine. I typically just don't recommend putting in a safe deposit box because if the individuals other than you and your spouse are not listed on there, it actually would require a court order to get into that box. And obviously you'd have to abide by banking hours. So if there's an emergency on a Sunday, you're gonna have to wait till Monday. So it's really just a personal preference.
All right. Thank you.
Can I go back real quick, Steve, if I
Sure,
could jump
absolutely,
in and can
of
talk
course.
about that personal representative? Let's say it's a situation like with my personal family where I've got three brothers. And my mom is deceased. My mom passed away. It was complications related to Alzheimer's. So I understand a lot of what happens with that situation. It was very complicated. And my parents, my mother specifically in this situation, did have a long-term care insurance policy. But I am the personal representative of my father's estate. But when it comes to naming beneficiaries to the assets, all four of us are listed as equal beneficiaries. So with Mariella, I agree with the comment, have one person, if possible, named as that personal representative, but don't have one person named as the beneficiary on your accounts, because then if it's a $100,000 life insurance policy and I get the $100,000 and I've got to give away $25,000 to each one of my brothers and I'm going to keep $25,000, I'm going to run into some gifting concerns there. So one personal representative if possible, but everyone named as beneficiaries.
Thank you for the clarification. Next question. If you move to a different state, do you need your trust to be revisited?
Oftentimes, again, the jurisdiction in which you reside are going to have unique laws, both tax laws as well as estate laws. So I do recommend reaching out to a local attorney to have them to review. Typically, the document says that there's a specific provision that the situs of the trust would not change based off of you relocating unless you choose to. For example, I have a lot of clients that flock south to Florida. It's a little bit more favorable from a tax perspective. So within the document, we put a language in there that allows them to officially change the status of the trust to not be controlled by Maryland law, but now to be controlled by Florida. So again, it doesn't hurt to have a local professional take a look at it to make sure it's still compliant.
Thank you for that. Should we have both a financial power of attorney and a medical power of attorney, or does the advanced medical directive eliminate the need for the medical power of attorney?
So you definitely need both documents. The advanced directive is something that is put out by the Attorney General, and they do have various components within that document that does include a medical power of attorney. I break my documents down just for clarity. It's unique to something that I specifically do for my clients. So you should have a financial power of attorney. There's actually one specific to the state of Maryland. It's called a Maryland statutory personal financial power of attorney. We no longer have a general durable power of attorney in Maryland. That actually went away October 1st of 2010. But you can have the Maryland statutory form along with the advanced directive that has the both living will component and medical power of attorney, and that would be sufficient.
Does the $10 million exemption apply only to individual owned assets? I.e., if the husband dies but wife co-owns an asset, is the asset subject to tax if it would cause total to exceed $10 million?
So the taxation would only come into consideration on the second spouse's passing. There's an unlimited marital deduction, not to get too complicated, but spouses can leave each other hundreds of millions of dollars and there's no tax consequences. It's when the second spouse dies, what do they own that would be subject to taxation?
Got it. At death, does a will need to be filed with the Register of Wills, assuming no assets are left?
Correct. It is a formal requirement and responsibility of the personal representative named within the last will and testament to file the will with the court. There is an accompanying petition document that needs to be submitted. It's called a will of no estate, meaning that there are no assets in the estate, but you still have to affirmatively file that original document with the court.
All right. What about life estate deeds?
So life estate deeds, there's two different kinds, but they are basically the equivalent of beneficiary on real estate. So there's one that is basically put in place to allow you to still maintain full ownership and control during your lifetime. And then upon your passing, it would directly go to whoever you nominate as the, and I'm quoting because this is the legal term, the remainderman, which is oftentimes your children. There's something called a life estate deed without powers, which kind of has some Medicaid planning components, which is a little bit complex and probably something that would need to be discussed on an individual level. But both of which of those documents are essentially beneficiary designations on real estate.
Okay. When a child inherits a life estate deed home, what is the basis of the house?
It should be a step up in basis to the date of death value. Again, that's a general answer.
Appreciated. Last but not least question, should I have all my kids on my checking/savings account? They already are equally left assets in my will.
No, absolutely not. So I never recommend having children on any assets with you as a joint owner other than the life estate deed, because that's a beneficiary designation. You can have them on there as your power of attorney so that they have check writing capabilities and can assist you from a financial standpoint. But you having them on there as a joint owner is essentially subjecting your assets to their creditor. So if one of your children gets sued, they would look at that account, and if there's 4 kids on there, they would basically state that that one child is a 1/4 owner of those funds, meaning that 1/4 of them could be used to pay off a debt or judgment owed by your child. So I highly advise against having children on assets with you in any capacity.
If I could jump here and with that answer a little bit more, is that for bank accounts, I would recommend, if you don't have it in place already, going to your bank or your different banks, depending upon how many you have, and asking them for a payable on death registration form, because every bank has it, even if they don't tell you about it, and most banks don't tell you about it. So your bank accounts, you want to have that POD, payable on death registration form, completed. And for your investable accounts, let's talk about non-retirement type accounts. In most cases, it's a T as in Tom OD form, a transfer on death form. So that way you can have those forms completed. And Mariella, if I'm being correct here, those assets will bypass probate with the PODs and the TODs. And in conjunction with having those powers of attorneys done, that's going to give your kids access to those accounts should you become incapacitated, while at the same time not listing them as an owner on the accounts.
And one follow-up point I want to make, if, for example, you have 4 children and you decide, well, my eldest is helping me with my finances or whatnot, so I've put them on as a joint owner. By the very definition of titling, you have effectively then disinherited your other children, because that one child, upon your passing as the surviving joint owner, becomes the owner of that account. And oftentimes I have clients say to me, oh, well, everybody gets along, they'll do the right thing, they'll share with their siblings. Oftentimes that doesn't happen. It's going to end up in court, and there's no legal obligation for that child to share with their siblings. In addition to that, once they become owner, if they start gifting to their siblings, then you have to worry about there being gift tax consequences if they're gifting over the $15,000 mark. So again, never put children on title with you, only as a power of attorney if they are acting in that capacity for you, or as Neil touched on, either a POD or a TOD.
And think about it this way. Let's say you've got a $100,000 traditional IRA and you've got 3 children. Well, we'll say 4 children, keep them easy. And you name child A, the oldest one, as the only sole beneficiary, primary beneficiary of that account, because they're going to do the right thing. So you pass away, that child, the oldest child listed as that primary beneficiary, gets the $100,000, and they're going to turn around and they're going to give $25,000 to the other 3 siblings. But who pays the taxes? You just had the oldest inherit $100,000. They owe the taxes. That person owes the taxes, and that $100,000 may bump them up into a higher income tax bracket. That's why in the scenario, if there's 4 kids, however many, if you want them all to get an equal share, especially on pre-tax retirement monies, I highly recommend you would list all them individually as primary beneficiaries.
We did have another question come in. Is it enough to have a child as a beneficiary on your bank account, or do you still need the POD form?
Well, that's kind of the equivalent. If they're already listed as a beneficiary, then that's exactly what you've already put in place as the POD.
Great. So does anyone have any other questions for our panelists today? Do you have time for probably 1 or 2 more questions?
If the questions are all done, we'll give it another second. I'd like to make a couple of closing comments before we separate for the afternoon.
Please do. We're getting a lot of thank yous, so I think everyone's enjoying it. So please,
okay. Here are some things to take into consideration. And Mariella, give me your thoughts on this. Let me paint a picture for you. You're 25 years of age, and you've graduated from college. You've had your first job, maybe your second job. You're feeling pretty good about it. You've got your boyfriend or girlfriend, fiance, whatever you want to call that person. You get married. So now you're 25 years of age. You get married. You buy a house together, you take out a life insurance policy, both of you are working. At age 30, you have a child. At age 32, you have a second child. At age 40, you're divorced because it happens. So now you're divorced, and at age 45, you get remarried and you've got your second spouse. And then at age 80, you sit down, and hopefully long before age 80, but for this scenario here, at age 80, you sit down, you think, you know what, I got to get my legal documents in place. And you get that will done, and you get the durable powers of attorney done, and you get the medical directive done. And then at age 85, you pass away. And you've got your spouse of 45 years who expects to inherit everything, but there's a life insurance policy out there, or there's a retirement plan out there that you had when you were married to your first spouse. So that's going back several decades. And now you've got this will that was updated when you were 80 years old, just 5 years prior to your death at 85. Who gets the money? That second spouse or the named beneficiary going back to when you were 25, 30, 35 years of age? And I think we all understand where I'm going with this, is that that first spouse is going to get the money because the beneficiary, the titling of the beneficiaries to those assets supersedes your will being updated. Mariella, am I correct by saying that?
100% correct.
So the point here is that as part of your estate plan process, it's an absolute priority to make sure all your beneficiaries are updated. People get married, people get divorced, people get remarried. They bring children in from another marriage when they get remarried the second time. And you've got to make sure you've got everything titled properly. And my final closing comment is that most people out there should really have three professionals that they deal with for some of the most important aspects of their lives. It would be the legal professional, the tax professional, and the investment professional. And if you have those three individuals already, if you sent an email to each one of those individuals and said, do me a favor, reply back to my email and let me know what you think my top 5 priorities are. Do you think that they're all going to respond with the same list of 5 priorities? Do they know one another already? If they don't, they may be possibly working for goals that are not in line with what the other professionals are working for. So teamwork and communication is key when creating and monitoring these documents moving forward. That's all I have from my end. Great information, great questions. I appreciate it very much. Time-wise, I guess we're a couple of minutes past the top of the hour. Steve, anything else from your end?
No, I just want to, again, thank everybody for joining us. This has been a very fantastic, very fascinating and informative discussion. We had a lot of great questions. I just want to thank you all for being here. Thank the audience, thank our panelists. We hope you can join us for some of our upcoming events. On December 8th, the Alumni Office will be hosting a virtual holiday cooking class. We have a chef that's going to be taking you step by step through the cooking. There's a couple spots left for that. And then on January 26th, we just announced a webinar entitled Tips for Filing Your Tax Returns. It'll be very timely. Again, kind of bounces off what we've learned a lot today. You can register for any of our events at the alumni website, alumni.towson.edu/events. I want to once again thank Kathleen Hyder for her support in this discussion. And I want to wish you all a very happy holiday season. We hope to see you all again at the next event.